You're not suggesting that Captain Coffin failed to take into account, are you?
I'd say we all fail to take into account a little bit.
Okay. So you don't believe this evaluation to be inaccurate?
I think if he was, other than the issues he was in, but that should have been taken into account in certain parts of the standard. But by the same token, that when you have a performance evaluation for a year, you still should not take an incident that's going on that's under investigation and halo the man and hurt him over it until you get all the final facts in.
And that's a good point. Wasn't the internal affairs investigation still ongoing at the time this performance evaluation was signed by Mr. Deane?
I believe it was, and you don't want to take, and you know, if the majority of the year is going on, good or bad, you don't want to take and halo it, and possibly if a man had come out of it, you don't want to destroy him because of something that was there if he hadn't been found guilty of it.
Right, so you think it was appropriate to give Mr. Deane these marks, irrespective of the fact that the IA was going on because the IA was not concluded, correct?
Yes, sir. I think it should have been noted in here, though, that he did have the items going on.
Okay, well,
And I don't see that it was.
okay, very well. But you don't dispute these marks that he was given?
Yes.
You don't dispute any of these marks that he was given?
No, no, no.
Okay, very well. All right, that was my fault.
Yeah.
Odd question. Okay. All right, now. I'm going to, again, ask you about your knowledge of the IA and its contents. Would you agree with me, sir, that at that party, there was no report of anyone being injured, especially the two girls that come here to testify today?
None that I know of.
No indication that they were harassed in any way?
None that I know of.
No indication that they were treated with anything but respect there, correct?
Nothing that I've heard any different.
Okay. So what happened there that night is that we've already disposed of providing alcohol to minors. What we're talking about here is Mr. Deane holding an open house party and allowing, really by omission, two girls who were under the age of 21 to imbibe. Would that be fair to say?
Yes, sir.
Okay. Now, there's no evidence these two girls got drunk, right?
Not that I saw.
Okay. And or that they hurt themselves or others on their way home, right? Okay. No indication they got into a vehicle accident involving property damage.
No.
No indication they did anything just to go home and go to bed, right?
I don't know after they
Okay.
left the house.
All right. Well, that's good enough. Okay. Now, does your agency conduct audits of David from time to time to make sure that that the system is being used solely for law enforcement purposes?
Yes, sir.
Okay. And have those audits ever come up with any wrongdoers, for lack of a better word?
Yes.
Okay. And can you tell me what punishment those wrongdoers received?
Off the top of my head, I can't think of anything.
Well, a David violation. A David violation would fall under, unless I'm wrong, it's on your termination letter right there. I think it falls under 86-4533,
Yes.
willful misuse. Okay. It says at the bottom of that, this violation may be sufficient grounds for disciplinary action ranging from oral reprimand to dismissal, depending on the seriousness of the offense and other circumstances related to the situation, right?
Right.
Now, the investigation conducted by A only found one David violation for Mr. Deane, correct?
As far as I know, yes.
Okay, all right. Now, during the hearing, and I think it's gonna, it was called a pre-disciplinary hearing, if I'm not mistaken, on the document that you're showing. Did Mr. Deane ever tell you that he agreed with your termination decision?
Well, he stated something to the fact of, I can't argue with you, the decision made, I understand it.
Okay. Now, you never agreed with the discipline that you provided, correct?
Not past that.
Okay. Now, and I know you went over this with Ms. Jones, but can you briefly tell me what you believe supported you going beyond a suspension of some sort, perhaps a last chance agreement, maybe even a lengthy suspension in combination with a last chance agreement, and led you to terminate Mr. Deane's employment?
If it had been any one of these, maybe any couple of these, maybe so, but when you put them all together, just the total amount, the total part of it is what came into it. If it had been to David, no, that'd probably been a letter of reprimand. If it had been, you know, the drinking, you know, the party deal, that would have been probably a suspension. But when you added everything together, you had to take, that's what brought it up to the position of termination.
Now, on page 3 of your your termination notice, dated June 22nd, 2012, you take the time to point out what you believe to be a lack of forthrightness.
Yes, sir.
By Mr. Deane. Do you see that there in the middle paragraph?
Yes, sir.
Did you understand from IA testimony and the IA report that Mr. Deane was intoxicated on the evening of this party?
I don't believe that I remember seeing that anywhere.
Okay. Now, let's just assume that he was intoxicated that night.
That he was or wasn't?
Was. And as an officer of the court, I can tell you that in his IA statement, Mr. Deane did make the assertion that he had been drinking, that he was intoxicated. So, but let's just take it on faith for now that Mr. Deane was intoxicated on the evening of the party. In your mind, sir, do you think that might explain why Mr. Deane was not able to give concrete answers to questions about what happened that evening?
It could have, but these answers right here was not, this is something I look at to see, are you giving forthright answers? You know, I look at it, would that make the difference between termination and suspension of?
So you would agree with me that a person who's intoxicated may not have a clear memory of events that occurred?
Oh, I know that.
Yes, very good. So it may not have been that Mr. Deane was being evasive or not forthright. It may have been that he just didn't remember because he was intoxicated.
Could be.
Okay. Now, the same to the questions about the beer pong on the fourth paragraph. And I'm not going to read his testimony from this, but he essentially says he doesn't know. Do you think that answer could have also been explained by the notion Mr. Deane was intoxicated on the evening of the incident?
If he's intoxicated, maybe not, but it's up to him not to get intoxicated until he uses one of our cars to play baseball.
Well, there's been no evidence, sir, that he did use car play beer pong. So now. Is there these offenses on the first page of this document, sir? There's nothing in here. None of these offenses deal with the arrest of Stephen DeHutt, right? In other words, none of these offenses pertain to the arrest of Stephen DeHutt, meaning that you felt there was something wrong about those circumstances that led you to find.
Yes, they do. Some of these do play into.
Okay, which ones are those, sir?
It's let's see here. The misdemeanor interest to the department, I believe is where that would go. But yes, that was part of what.
That's where I was confused before. I thought I heard you say that during your examination by Ms. Jones. What crime was committed by Mr. Deane in relation to the arrest of Mr. DeHutt?
That was policy and procedure violations.
Not a misdemeanor. A misdemeanor in jurisdiction of the department, unless I'm misconstruing this, means that a crime was committed And the sheriff's office, in addition to little fees.
Well, I may be putting it under the wrong one, but it is a policy and procedure violation, that's what he was guilty of.
What policy and procedure violations?
That you will not be involved personally with this kind of case. I don't have it right here in my hand.
Well, that was.
Where you're not to be involved with neighborhood disputes or, or family disputes.
I guess my point is that offense was not charged, was it? It's not, and forgive me, I don't see it on the determination that was dated June 22nd, 2011.
So I figured file a directive order.
Okay.
That's policy, that'd be the policy and procedure.
Well,
Well, they shall adhere to all official directives and orders and shall
What-
faithfully execute all the duties and responsibilities of their assigned position. That's the policy and procedure violation.
What order is there specifically that prevents Mr. Deane from undertaking the conduct that he did in this instance in respect to completing the charging affidavit himself and
The
investigating
policy and
himself?
procedure, you will not be involved in family, or that person involved in things.
Do you know the number of the policy?
Our policy and procedure manual is.
Voluminous, I've seen it.
Yes, and
Do you know what it says?
exactly, no, I can say exactly right.
So can you say for a certainty, as you sit here today, that Mr. Deane violated the letter of that policy?
Yes, sir, when we looked at this, yes, he had violated it.
And how did he violate it?
Not being personally involved with this domestic violence case, following it all up himself, instead of not having somebody else follow it up, as you should.
Did he try to have somebody else follow it up by going to Mr. Sean McGuire?
I don't believe so. He just gave a part of it, as we said earlier. He told a part of it, not the whole part of it, and that's by omission.
Let's move on to a different topic. Mr. Deane is not the only employee of the Sheriff's Department that's had his share of alleged disciplinary problems. Is that fair to say?
That's what it said.
One of those persons that has had a history of, well, I'll strike that. One of those problems that there's deputies that had a disciplinary situation was Anthony Zimmer, correct? And, yeah. And you recall Anthony Zimmer, correct?